Yang pertama kita akan membicarakan soal IP rights law in European countries and also in Asia, dan bagaimana impaknya kepada industri kreatif. Kita di sini nanti para pakar akan berbagi pengalaman di region mereka dan apa yang kita bisa aplikasikan di Indonesia. Yang pertama adalah Bapak Neil Gane as the Executive Director of the Asia-Pacific Internet for Motion Picture Association (MPA). Mr. Neil Gane, would you like to join us on stage? Dan yang kedua, Bapak Kwee Tiang, Regional Director for Asia-Paicifc, International Federation of the Phonographic Industry. Hai, terima kasih dukungannya. Saudara Kwee-nya, kenapa ketika fotografi industri langsung tepuk tangan atau MBA nggak tepuk tangan? Tepuk tangan juga untuk Mr. Gane. And last but not least adalah Bapak Choi In-guk, Head of Anti-Piracy Program KOFIC. Choi, silakan tepuk tangannya untuk Pak Choi. Acara ditemani oleh penerjemah karena nanti presentasinya dalam bahasa Korea. Baik, kita langsung saja mulai. Mr. Gane, you're up first.
Welcome. Thank you very much for attending this very important forum. Important not just from an Indonesian film industry standpoint, but from an international film industry standpoint. And before I start, I'd like to thank Shia Timothy for the great work you've coordinated this forum. I'd like to touch upon sidewalking, but sidewalking from the Asia-Pacific standpoint. I represent the Motion Picture Association, which is the 6 major Hollywood studios. We have representation around the globe, not just in Asia, but also in Europe and North and South America. And sidewalking is one of the tools that we use throughout the world in a very efficient and effective way. But it's not the only tool, and there is no one silver bullet to managing, fighting, deterring online piracy. It really is a collaborative effort, looking at various pillars. Firstly, wider availability of content. And this is something that both the local and the international film industry are doing throughout the world, making content more readily available at reasonable price points and on platforms that audiences want. Secondly, ongoing educational campaigns, which identify the positive outcomes for consumers who can then value the contribution that intellectual property provides to their well-being of their lives. Thirdly, industry partnerships. This is really around good governance partnerships. A lot of intermediate service providers can do a lot more in working with content providers to protect intellectual property. And finally, workable legislation. And this brings me on to sidewalking. Now, why block sites? Well, it's not people get involved in piracy. They're not doing it for the freedom of speech or for freedom of information or to improve technology. They do it for the money. You know, it's a very profitable crime. Unfortunately, it's low risk, high gain. It's a crime that affects both the local film industries, whether Indonesian, Filipino, Korean, and also the international film industries. And it's also one that impacts other areas of life as well. On the right, this is actually the Pirate Bay, and it's looking for a TV show called Once Upon a Time, which is a 7 to 12-year-old demographic. And if they search this on the Pirate Bay, this is the type of advertising that gets wrapped around it. And it's no different from an Indonesian Pirate Bay. Again, it's the same film title, Once Upon a Time, and this is the type of advertising that gets wrapped around it. This is the type of images and potential doorways that are served up for young children. As well as other scams, as well as the Indonesian flags given their legitimacy. This is an issue that's shed some concern around the world. You know, what impact does it have on children? this sort of high-risk advertising. And there's some research that was undertaken in Australia 2 years ago, which looked at 12 to 17-year-olds and asked them, how prevalent is this high-risk advertising when you go onto piracy sites? And they found the most prevalent type of advertising that they saw was either sex industry or illegal gambling sites. It's also an area of research, and some of you may have received this. This is a piece of research undertaken by an Australian academic, and he's undertaken the same research in a number of countries, including Indonesia. And when this research was first undertaken in Australia, it was picked up by John Carr, who is on the board of the UK Council on Child Internet Safety, which is the primary go-to foundation for online safety for the UK government. And he said this: by accepting advertising from these dubious sources, piracy site owners are showing that their snaps are well and truly in the sort of money trough no respectable or ethical business would go near in a million years. Parents who may not have bothered much about their children's engagement with piracy need to know about this aspect. Right now, I'm afraid largely they don't. On Indonesian piracy sites, what we are seeing is 84% of the advertising that these site operators monetize is high-risk advertising. And what type of high-risk advertising? Predominantly illegal gambling. 75% is illegal gambling. And then sex industry and malware. And this is a typical site. This is an Indonesian site, whether it's international or whether it's local content. And this is the type of advertising from gambling to sex industry to malware that's wrapped around it to monetize, on which children could well click on and enter a particular doorway. Now, site blocking is not something new. It's widely used throughout Europe. 32 countries in Europe now have legislation that incorporates provisions for blocking of sites. And MPA in Europe has either directly themselves or through their local partners they're blocking orders in relation to 168 sites in 13 countries. There's also administrative site blocking in Malaysia, South Korea, and we'll hear more about South Korea in a few minutes, as well as Indonesia, Thailand, and there's now judicial site blocking implemented in Singapore. In Malaysia, regular administrative site blocking has been going on since 2011, and now approximately during that period over 40 piracy sites have been blocked. In Korea, as I said we'll hear more later on, over 85 sites have been blocked since April 2011. Indonesia, we applaud the Indonesian government for recognising that this is an effective tool that can be used to protect your film industry, and they passed amendments to the Act in September 2014, and they're close to finalising and releasing the implementing regulations to allow site blocking to take place in Indonesia. In Thailand, there's been amendments to the Computer Crimes Act, which is currently before the State Council, which again will allow for regulatory site blocking of piracy sites. So this is not a new piece of legislation. And in Singapore and Australia, as I said, there is judicial site blocking, where it's a court process. Now, if I could just briefly touch upon the legal foundation of judicial site blocking in Europe, and Katie will talk in more detail later on. But the origins of this were a European copyright directive, which emerged throughout Europe, in particular Article 3 of the Copyright Directive, which provided that rights holders could seek an injunction against intermediaries whose services are used by a third party to infringe copyright without having to prove liability on the part of such intermediaries. So it's essentially a no-fault injunction. The directive does not interpret or define what an intermediary is, and thus far with the jurisprudence throughout Europe, intermediaries have been ISPs, hosting service providers. They've even found to be search engines, and there are two countries, France and Portugal, which have identified search engines as intermediaries and issued blocking orders against those search engines. The fundamental idea is under Recital 59, which is all part of the Copyright Directive, which acknowledges that, firstly, in the online environment, intermediaries are used by third parties for infringing activities, and that those intermediaries are often best placed to bring such infringing activities to an end. Now, outside of Europe, there is no copyright directive. There is no broad unilateral directive with supporting recitals across Asia. So instead, those countries thus far, Singapore and Australia, who have adopted a judicial approach to site blocking, have tended to look at 97A of the UK Copyright Act and use some of that jurisprudence to be able to create a threshold test for how a piracy site can be defined, and this threshold test is something that the courts take into account. In Singapore, the trigger that would define a piracy site is it has to be flagrantly infringing. And in the Act, it lists a number of parameters that the courts may take into account to identify the site and whether it meets that particular threshold test. These parameters will be whether the primary purpose of the site is to commit or facilitate copyright infringement, whether the blocking location makes available indexes or directories to assist in the dissemination of infringing content, whether the operator of the site shows a clear disregard for copyright, whether the site has been disabled in another country, blocking orders whether regulatory or judicial have been ordered against that particular site, or whether the online location contains guides or indexes, and also the volume of the infringing traffic. In Australia, where there is a bill before the government, and it's close to being put forward to Parliament, hopefully in the next few months, you'll notice they follow a similar scheme, looking back at jurisprudence in Europe. Their trigger is the site has to have a primary purpose of being one of infringement. And again, they list out a series of factors that the court can take into consideration. And you see a lot of similarities between the Singaporean approach and the Australian approach. Flagrancy of infringement, whether the online contains directories, indexes, etc., whether the operator disregards the copyright, whether it's been blocked in another jurisdiction. So these seem to be the trend when looking at judicial site blocking, looking back at what's happening in Europe and using that jurisprudence to inform the court. Now, is site blocking effective? A key question for all administrators and also for consumers. Well, we would argue that it is, and we would argue that there is proven facts and data to support the conjecture that it is. Last year, there was an In-guk report, it's a third-party entity, and it looked at the most popular 250 most popular piracy sites in the United Kingdom. Some of those were blocked, some of those were not subject to site blocking orders. And it had a number of key findings. The first key finding was that those sites that had been ordered to be blocked by a court resulted in a significant decline to the traffic going to that site. As an example, Easy TV, the blocking order was implemented in July 2013 and resulted in an immediate decline in traffic of nearly 85%. The Pirate Bay, this court order was implemented in July 2012, and again, an immediate decline in traffic of nearly 84%. It also found that traffic to block sites plunged on average 77.5%. And not only did they plunge, but as you can see from this diagram, base stayed low, they did not recover. It was a permanent, not a temporary, reduction in traffic. It also looked at the 250 sites that had been blocked. 250 sites that had been analysed. Not all of those had been blocked. And it found that amongst all 250 sites, there was a 22.9% reduction in traffic to those sites. Now, this was compared to those same sites in Europe, where it had nearly an 8% increase in traffic. So, looking at this, you can see to the left-hand side, these are the sites that have been blocked in the UK, and you'll see an average of over 75%. Even those 250 sites which were not subject to blocking orders still had a reduction of nearly 22%. Compare that to the rest of Europe, those block sites in the UK, traffic actually increased by 20%. Those sites, other sites that weren't subject to blocking orders in the UK, increased by nearly 8% outside of the UK. So blocking clearly works. Now there's been some conjecture that it doesn't work because customers will simply go to multi-site proxies and access the websites that way. Well, there was an increase in usage of multi-purpose proxies, but as you can see, the increase was insignificant compared to the reduction in traffic that was going to those block sites. So, in conclusion, we are finding that site blocking is effective, it does work, and it doesn't just work in terms of providing more access and people moving towards legal content. It doesn't work just in terms of reducing the money supply and the revenues that go to these illegal operators that monetize this infringing content stolen from Indonesian filmmakers and international filmmakers. It will also prevent this type of high-risk advertising from being seen by children, seen by consumers, which is riddled with very graphic images, riddled with malware, and is also a potential first road to access to very graphic pornographic sites or to gambling sites. On that note, on that image, I'll pass you back to the moderator. Thank you very much.
Thank you very much. Jadi berdasarkan studi di Inggris, site blocking itu efektif. Apakah itu bisa diterapkan di Indonesia? Kita nanti akan bicarakan lebih lanjut. Tapi sebelumnya kita lanjutkan ke pembicara kedua, Mr. Kwee Tiang, yang akan membicarakan bagaimana website blocking di Eropa dan akan menyentuh sedikit pengalamannya atau studi yang dilakukan di Taiwan.
Thank you very much. Good morning. I come from IFPI, which is the global association representing the association representing the global music industry. As we heard this morning, the music industry is very closely associated with the movie industry. So let me start by sharing with you the current state of the music industry globally. You see that in fact the industry has been declining. In 2013, it fell from almost $30 billion to only $15 billion. We just released our 2014 figures, and there is a slight fall of 0.4%. So for the first time, we have fallen below now $15 billion. So the music industry is not doing very well, but we also know that in fact the consumption of music globally has been growing. Almost all of us have music on our mobile devices. We attend a lot more music events and so on, but the state of the global music industry has been declining. And the main reason obviously is digital piracy. You have heard Neil speak at length about what has been done as far as website blocking is concerned to try to control the situation with regard to digital piracy. The basic point is this: we cannot compete against free. If you can go online and get your music for free, you are not going to pay for your music. So it is totally an uneven competition, and we're never able to win this battle. Therefore, the focus of my discussion this morning actually will be on digital piracy. We have a lot of legal services now, over 500 legal music services worldwide, compared to only 5 about 6 or 7 years ago. So a huge growth in the last 5-6 years. The illegal services are competing unfairly with the legal services. let me share with you the reason why people go to illegal sites. As you can see right at the bottom, we did this study in Taiwan last year. It was conducted by a third-party company, but the study shows obviously the main reason why people go to illegal music sites is because it is free. Now, they go to these sites despite the fact that they are aware this is wrong. It is an illegal activity, it is theft. 81% of Taiwanese people in the survey indicated that they know visiting pirate sites is stealing. Okay, very clear response from the people who are being surveyed. Next, they are also very clear that visiting pirated sites damages the industries. It leads to job losses, it leads to financial losses, and it damages moral values. So, as I said, we did not control this survey. This is a survey of, let's say, you guys sit here. What is your response? So this is in Taiwan, a very clear-cut indication that the public is fully aware that their activities is very damaging. Now, for some time, there is then the response from governments that, well, you don't have sufficient legal sites available. Now that is, as I said, no longer true because we have digital content available. You go to Spotify, the latest music is available. You go to Apple, you go to KKBox, you go to domestic information services, legal services. All the music is available. So you can see that 74% of the Taiwanese public says they know they can go to legal sites and get the music. Alright? And this is a statement released by Groove Shark last week. I will come back to Groove Shark. But Groove Shark, as you know, is one of the one of the worst music pirate sites. Groove Shark itself says there are now hundreds of fan-friendly, affordable services available for you to choose from, including Spotify, Deezer, Google Play, Beats, Rhapsody, and so on. So legal services are now available. Yet, look at Taiwan. Almost 75% have visited pirate sites, and almost 60% continue to visit pirate sites. So the situation is not a simple one where we say because they don't know, because there are no legal services available, lack of education, and so on. The situation on the ground is not very, very clear. They know what they are doing, they know it damages, they know legal services are available, yet they go to piracy. So what do? We need a host of measures to tackle digital piracy. And Neil has spoken at length on website blocking. I will also do that more from the basis of what has been happening in Europe. And from here you can see that in fact it has been taking place in a lot of European territories, and the courts have ordered the ISPs to block at DNS and IP levels. There was always this question, and continues to be this question of cost. Who is going to pay for the blocking? Right? And if you look, the courts generally almost always say it is the ISP's responsibility to pay for the blocking of this point. But what has happened recently is Finland has become the first country to legislate 1 month ago. They put it in the copyright law to say the ISP is responsible for the cost. They can claim it back from the infringing site operator, which is a brilliant piece of legislation, don't you think? But not from right holders. Because all along ISPs have now given right holders should pay. We shouldn't have to pay. But I think the Finnish legislators got it very correct. If you want to claim cost, get it from the site that have been giving access to illegal sites. Now let me come just to list some of the countries. Neil has mentioned all 22 EU countries, 38 plus the Nordic countries should have site blocking legislations in place. These are the countries where active legal actions and implementations have been made. I think the slides will be circulated, you can look at that. Effectiveness. Neil has given you the figures, so I will not go into detail, but you can see EU countries with block, EU countries without block. There's a huge difference between those countries with and without block. I said I'll talk about group shot. Maybe a quick show of hands. How many of you are aware of this site called group shot? No? I think our Korean friends maybe because they block group shot. But what happened, you can see when group shot was blocked in Denmark, that is the trend, okay, keep falling. How many of you are aware that group shot shut down permanently last week? Very good. You know, after I hope you're happy, not unhappy. But anyway, after massive battles, my member companies had to sue group shot in the United States, and as a result of the legal action, group shot finally shut down at the end of April. They issued a statement apologizing for the actions, which is nice, but they actually caused tremendous damage to the music industry, development of the music industry. So group shot is gone, but I think before it went down, we were effective in blocking access to the sites. Now let me deal with a number of arguments that have been raised about website blocking, against website blocking. First, they say it involves censorship and it is against fundamental human rights of communication. It can be circumvented and it is not effective or proportional. The European courts have actually dealt with this question specifically, and I'll come to it, about its effectiveness, about impact on human rights and effectiveness. Now, you'll see that despite the fact that it can be circumvented, the EU court have actually held that it is the only real effective way for right holders to address online piracy. Okay, so the courts recognize it can be circumvented, but it's the only effective way. And this is an example for you. In Italy, after blocking came into place, our Federation did a study and found that there's a 25% increase in visits to legal music sites and an 80% growth in streaming revenues. So obviously, it is effective. Freedom of speech, very important for all of us. As some of you may be aware, I think Neil has an ex-enforcement background. I have an ex-enforcement background. I was a Singapore police force. The basic point is this. The pirate sites are illegal sites. In some countries, it's considered a crime. All we are stopping is access to a criminal site. Today, if I open a store selling pirated CD outside this hotel, I'm sure every one of you here will agree that's illegal. The police can come and shut down that store. That store now moves online, and suddenly it becomes a fundamental human rights issue. You see, the argument doesn't follow, but you will find that many people online will argue that if I stop access to the legal site, it seems to be an infringement of the fundamental right to communications or speech, which obviously is incorrect. And the EU courts have actually come to the same conclusion that EU courts have said that this is not protecting copyright is in itself also a fundamental right. Okay, and this is a court decision. This is not what my association is saying. Let me quickly run through because I want to share with you a couple of other points. Aside from site blocking, there is this other thing called the graduated response system, or what we call the 3 strikes rule. What happens here is if you are found to be visiting illegal sites, 1 warning will be issued. A second warning will be issued. And these warnings are actually more educational, right? To let you know you are visiting illegal sites is not the right thing to do. And of course, if you persist, then there is a likelihood your internet account can get suspended. Alright? The French government were the first to start this, and they found it very useful particularly from the educational point of view. And I just want to share with you the statistics so you can have an idea of the effectiveness. You will see that in fact over 3.3 billion messages have been sent now. Okay? This represents only about 9% of internet users. In other words, only 9% of internet users have received first warning notices. The second warning notices went up to only 300,000. In other words, what is the conclusion you can draw? That in fact, 90% of people who receive a warning stop. Either stop, or of course they could use another account. Alright? We recognize that. But the effect is 90% didn't receive the second warning. And then when you go to the third warning, even less than 1,005. Right? So obviously when such notices are sent, people act on them. Because most of us is like me, I live in Hong Kong. So I have a tendency sometimes, maybe I shouldn't say I was about to share with you, I tend not to respect the traffic light. When I just cross without seeing whether it's green or red. So when I came back to Singapore recently, I just crossed the traffic light, because it was clear, there was no cars. I crossed the light, and then the policeman appeared, and I'm an ex-policeman, right? The policeman appeared and said, I'm going to fine you for jaywalking. It is this. After that, I stopped jaywalking again in Singapore. And so far my behavior in Hong Kong hasn't been affected, but it's simply messaging, letting people know, please don't do something which is illegal. Alright, so I think we believe this is very, very effective. This is one of the measures that we feel should also be introduced aside from website blocking. So you can see all these statistics to show that 70% of subscribers declared reduced their activity, 88% reduced after second, and so on. And in fact, 73% say they have not gone through other means to access current sites. And 23% say they moved to legal platforms. Alright? Advertising, of course, is supporting the pirate sites. I am running a little bit out of time, so I will wrap up. Neil has shown you all the scam and illegal, I would say illegal, high-risk advertising that appears on these sites. Okay? Our basic point, of course, is internet service providers also have a legal responsibility in this fight against digital privacy. Search engines are responsible for, when you key Lady Gaga MP3 for free or pop-up, that tends to guide you towards illegal sites. Right? So I think they have a responsibility. We are pushing hard in our negotiations with Google to try to change the way the search engine works. Litigation, of course, is important. I shared with you about Cruise-Shark, and Cruise-Shark is now finally shut down. Our Korean friends are here, so I'll leave them to talk to you about the situation in Korea. Just quickly, when you see the IFPI represents the global music recording industry, and we look forward to your cooperation in the fight against digital piracy, so that we can all enjoy quality content, whether in terms of music or in terms of movies. Thank you very much.
Looking forward to Mr. Choi In-guk, Head of Anti-Virus Program from KOFIC, South Korea. Silakan untuk teman-temannya untuk mendekat.
안녕하세요. 먼저 발표에 기회를 주신 분의 시와 관계자를 감사드립니다.
Before I begin my presentation, I thank everyone for giving me this opportunity to talk.
용어에 대해서 말씀을 드려야 되는데요. 극장을 제외한 나머지 시장에 대해서 디지털 온라인 마켓이라고 이해를 하시면 됩니다. 그 2차 세컨더리 마켓을 디지털 온라인 마켓이라고 한국에서는 이해를 하시면 됩니다.
Talk about terms here. It's basically the digital online market in Korea.
그 흐름을 보면 2000년도에 인터넷이 발달하면서 기존의 기기기능 디스크 시장이 축소되고 인터넷 기반으로 한 사업이 2009년부터 활성화돼서 부가시장, 2차 시장을 활성화시키기 시작했습니다.
First keyword, deeply down and up. By the year 2000s, internet started to spread in Korea, and as it happens, physical markets such as DVD shrink down.
그리고 2012년부터 이제 웹하드를 축소한 형태의 불법 사이트라고 이해를 하시면 되고요. 이 웹하드에 대해서 정책을 펼쳤고, 그 이후로 웹하드는 축소되었지만 기술의 발전 등으로 빠르게 또 다른 불법 사이트나 매체들이 지금 등장하고 있습니다.
As 2012, WebPart, a special type of illegal platform, appeared. Although we were able to block it, the internet environment is fastly changing fast. So all kinds of new media piracy is occurring in Korea.
간단하게 한국의 2차 시장에 대해서 설명을 드립니다. 합법적 시장인 IPTV와 디지털 케이블 TV 시장과 그리고 인터넷 VOD 그리고 DVD나 블루레이 등의 기존의 피지컬 시장이 있습니다.
The actual online market in South Korea can be divided into two parts, legal and illegal. First, the legal market. On TV is digital cable TV, what we call a set-top box. It provides internet VOD service. The customers can watch movies online at home using TV.
그리고 불법 시장으로는 여기 웹하드 시장과 그리고 모바일 그리고 어플리케이션 그리고 토렌트 이러한 시장들이 불법 플랫폼으로 지금 이해되고 있습니다.
And for the illegal platform, web parts, mobile apps, torrents are taking place.
이해하셔야 되는 게 웹하드에는 합법적인 콘텐츠도 제공이 되고 불법적인 업로드 다운로딩이 되고 있습니다.
And what's special about web part is that they both have legal contents but also illegal contents.
여기 수치를 보시면 그 한국의 그 세컨더리 마켓은 지속적으로 성장하고 있고 연평균 11%의 성장을 하고 있습니다.
Well, if you see the secondary market of Korea is gradually increasing, but the rate of increasing is simply dropping.
2013년 마이너스로 2013년, 2014년이 인터넷 구입률과 마이너스 성장을 기록한 것은 아까 말씀드린 웹하드에 대한 제재가 주요했기 때문입니다.
The reason why internet VOD came down from 26.7 to minus 31.5 is the appearance of web hard.
보시면 2차 세컨더리 마켓의 주요한 수익원은 IP가 KOFIC이고 나머지는 1.9 차지하고 있습니다.
This proportion of the DVD Blu-rays, internet viewing, IPTV stake,
그리고 한국의 전체 영화 산업을 보면 극장 수익이 많은 비중을 차지하고 있고 나머지가 아까 말씀드린 디지털 온라인 마켓, 즉 세컨더리 마켓으로 이렇게 구성이 되어 있습니다.
this is total revenue of Korean film industry, and theatrical part is taking most of the profit.
이 세컨더리 마켓을 극장 수익과 비슷한 수준으로 키워가지고 전체 영화 사장의 규모를 늘리는 것이 저희 목표입니다.
Our goal is to develop this ancillary market sales into a level which is similar to feature film.
그러면 주요한 그 불법 유통 사이트 웹하드에 대해서 어떤 식으로 이루어지고 있는지 그 제도와 구조에 대해서 말씀드리겠습니다.
I would like to explain to you about how webpart works.
웹하드에 대해서는 합법적 계약을 맺은 콘텐츠가 제공이 되고 그리고 불법적으로 업로더들이 콘텐츠를 올리고 동시에 이루어지고 있습니다.
The webpart, there is a content provider. The provider uploads contents legally through contracts, but also anybody can be an uploader. They can upload any file, whatever they like.
불법적 콘텐츠를 제작하기 위해서 기술적 보호 조치와 상시 모니터링을 시행하면서 웹하드 예정 규제를 시행해왔습니다.
And to suppress these uploaders, we need monitoring and technical action.
약간 지루한 부분이 될 수 있는데요. 이 저작권법 관련해가지고 웹하드에 대해서 어떻게 근거를 가지고 있는지 말씀드리겠습니다.
It might be a little bit boring, but this is a legislation Korea made for the prevention of illegal distribution.
2011년도에 그 웹하드에 대한 제재를 하면서 웹하드 등록제라는 시스템을 시행했습니다.
Since 2012, the webpart registration system has been implemented.
주요한 내용은 기술적 보호 조치, 그리고 24시간 모니터링, 그리고 일정 규모의 자본금을 가진 회사를 등록하였습니다.
What's important is those who want to operate webpart must have the potential of technical action and 24-hour monitoring staff and capital of $300 million once approximately.
그 웹하드에 대한 주요한 근거법은 요약해서 말씀드리면
Let me summarize these two.
그 불법 파일이 유통된다고 생각이 든다면 그 웹하드 사이트에 대해서 그 자신의 콘텐츠를 내려달라고 요구할 수 있습니다.
If you feel this webpart is distributing illegal files, anyone can sue them.
그리고 기술적 보호 조치를 요구할 수 있습니다.
And they can ask for technical actions to their files.
그리고 133조의 근거 그 불법 그 기술적 보호 조치에 우회하는 장비들을 수거해가지고 폐기할 수도 있고 불법 복제물을 수거 폐기할 수 있는 근거를 들었습니다.
They can also request the courts to destroy any equipment, devices, or information programs that infringes their property rights.
그리고 133의 조를 보시면 4회 이상 경고를 받은 그 업로더나 또는 그 게시판에 대해서 6개월 이내에 그 정지를 시행할 수 있는 근거를 두었습니다.
Well, the court gives warnings, and if a site receives more than 3 warnings, then they can be now blocked or permanently shut for a set of period within 6 months.
그리고 온라인 서비스 프로바이더즈, 인터넷 서비스 프로바이더인데요. 이 불법 파일 유통된 근거가 있다면 제재할 수 있는 근거를 두었습니다. 그러면 이제 한국에서 이 보호 시스템이 어떻게 이루어지고 있는지 구조를 말씀드리겠습니다. 그 문화체육관광부라고 정부기관이나 정부부처가 있고, 그리고 그 밑에 저작권 보호위원회, 그리고 저작권 보호센터, 그리고 방송권 아니면 사법경찰이 같이 작업을 진행하고 있습니다.
Well, this is copyright protection system in Korea. On top, we have Ministry of Culture, Sports and Tourism. Under that, we have Korea Copyright Commission, Copyright Protection System. At the very left, the Copyright Special Judicial Police.
영화산업의 경우 코픽과 그리고 콘텐츠 관리자들이 같이 협업을 해서 진행하고 있습니다.
In the case of KOFIC, this content to provide, and KOFIC is
불법 복제물의 시장을 보면 한국에서는 영화산업이 가장 많은 경우입니다. 한국의 불법 시장을 보면 영화 산업이 그 규모를 가장 많이 차지하고 있습니다.
It's the blood market of Korea, and film is taking the most largest proportion.
그리고 이제 불법 복제물에 대한 단속식입니다. 보시면 2012년도에 최고치를 찍고 2013년도에 수치가 좀 줄어들었습니다. 단속 실적입니다.
This is the results we gained from illegal reproduction crackdown performance in Korea. We were very successful in 2012 and 2013.
이렇게 줄어든 이유는 기술이 발전하면서 스트리밍 사이트나 또 다른 모바일 기반으로 한 여러 가지 새로운 뉴미디어로 계속 소비자들이 옮겨가고 있기 때문입니다.
The reason why is because customers, illegal sites are changing into new media such as mobile apps and smartphones.
실제 단속 수준을 보면 2014년에 아까 말씀드린 사법경찰들이 단속해가지고 169건의 사이트에 대해서 제재 조치를 내렸습니다.
Special Judicial Police were able to shut down 169 illegal sites.
자, 그러면 이제 한국의 영화진흥위원회가 독자적으로 수행하고 있는 사업에 대해서 말씀드리겠습니다.
This is a KOFIC's separate business we're doing it on our own.
24시간 웹파 모니터링 시스템을 이제 감시하고 있고 그에 대해서 이슈 리포트를 발표하고 있습니다.
This is a 24-hour web park monitoring system and issue reports. Here we can check the contents that come up at the web park, whether it's legal or illegal, 24 hours real time.
그리고 특별히 이제 극장 개봉 중이거나 세컨더리 마켓에 상영되기 전에 영화에 대해서 특별한 감시 시스템을 시행하고 있습니다.
We keep our focus mainly on the movies that are currently showing theaters.
그 활동을 통해서 이제 설국열차나 수상물에 대해서 조기 파일을 확보하고 차단하는 실적을 기록했습니다.
This screen capture is capture of the moment we detected prior leakage of someone recording the film Israeli Snowpiercer right in front of the screen.
불법 시장에 대해서 제재하는 것도 중요하지만 합법 시장을 키우는 것도 중요한 일입니다.
It's important to suppress the illegal market, but it's also important to develop the legal market.
지금 극장처럼 세컨더리 마켓에서 매출이 어느 정도 일어나는지를 전산으로 시스템화하는 작업을 지금 추진하고 있습니다.
And to do that, we need accurate data. All theaters have this computer ticketing system at the counters. We're planning to take this online all the way so that every single ticket sold can be traced. Therefore, we have accurate sales data. That needs clarity. After that clarity, we can bring stabilization, stable market, and stable investment.
그리고 그 소비자들이 불법이라는 인식을 심어주는 것도 중요한 작업인데요.
It's also important to let people know that illegal sites are wrong.
굿 다운로드라는 캠페인을 2013년까지 진행해서 소비자들의 인식 제고를 추진하였습니다.
We have been working on this campaign, our group downloader, from 2003 to 2014.
마지막으로 말씀드리면 콘텐츠가 영화뿐만 아니라 다양한 콘텐츠에 대해서 불법이 동시에 진행되고 있습니다.
Lastly, illegal distribution is happening on films. Not only that, other contents such as music, games, songs, cartoons. We need to broaden our boundary of contents.
그리고 해외 서버를 둔 사이트들은 단속하기 힘든 부분이기 때문에 국제적으로도 규율을 해야 됩니다.
And one more, we hope for international corporations because illegal websites inside Korea, we can catch them, block them, but sites that have their own foreign IP addresses, we can't do anything about them inside Korea.
그리고 마지막으로 스마트폰이나 그 새로운 유미들이 계속 나타나고 있기 때문에 이 부분에 대해서 다른 플랫폼과 협력을 통해 가지고 빠른 조치를 진행해야 됩니다.
And because these illegal sites, illegal distributions are moving to smartphones area, we need to cooperate with smartphone companies too.
이상입니다. 감사합니다.
Since we have a little bit of time for Q&A session, mungkin ada yang ingin bertanya sebelum kita melanjutkan ke sesi berikutnya. Silakan Mbak, diri disebutkan nama dan juga institusi yang diwakilkan. Mohon baiknya.
Hello, my name is Kwee from Jakarta International Office. I'd like to ask the panel's opinion on whether piracy helps to expand the market. Like, for example, I believe Korean film and music is very famous here in Indonesia, but they also don't distribute their music and films here. But they're still famous here in Indonesia anyway. So, in regards to the market, how are you going to tackle piracy? Thank you.
The question was my understanding was about whether piracy is actually benefiting the content industry for smaller production. I mean, we wouldn't agree with that. I mean, this is a form of sampling. Often what's being used is samples. We want to sample it before we buy it. I mean, in the case of film or TV, you have to sample it. You've consumed the whole product. You've watched the whole film. You've watched the whole TV series. And the likelihood of a large percentage of those people sampling that particular film and TV, then going on to purchase, is very slim, has been proven in a lot of research to be very slim, and is certainly not sustainable for whether it's a small industry, a local industry, or an international industry. It's just not sustainable. Creative content needs to get returns on its investment, and the currency of your time for watching it is not a currency that actually can be then reinvested back into a new product. The only currency that can be invested back is actually the currency of money.
I would add that in fact for what we call the independent companies, the smaller companies, it is even more important that piracy has to be controlled. Because for a big company, let's say for Universal Music or Sony Music, they have the financial strength and capability to fight as well in the markets. For the independent producer, while their music may become more recognized, they have no financial returns. Without a financial returns, they cannot move on to the next project. So I think the biggest difficulty for indies actually is to make sure that they get financial returns. And piracy obviously doesn't help them in this regard. Thank you.
실제적으로 그 도움을 주고 있습니다. 예를 들면 그 매출이 불법적인 사이트들을 이제 많이 줄어들었고요. 그때는 합법적인 사이트, 특히 IPTV가 매출에 대해서 많은 신장을 기록하고 있습니다.
Sorry to say, in Korea, this piracy is actually helping in sales. IPTV, which is mentioned, is what takes the most sales proportion in film industry in Korea. It's increased piracy.
불법 사용자들의 일부가 IPTV로 옮겨갔다고 이해를 하시면 됩니다.
I would say it's not illegal, but people who were operating illegal sites, they all have moved into IPTVs.
Sudah? Ada yang ingin bertanya lagi? Silakan Ibu. Boleh disebutkan nama dan juga wakilnya. Ya, silakan Mbak di depan, baris kedua.
Thank you very much. My name is Narendra Ayu. I'm a Commissioner of National Collection Management Organization in Indonesia, as well as academics of IB from Faculty of Law, University of Asia. I would like to ask a simple question actually about the procedure how to submit a complaint, because it will be possible we think that CMO or national CMO has a legal standing to make a complaint to ask for action like site blocking, because we play in the virtual area, so how if we have to make a complaint virtually. Thank you.
Maybe based on your experience, on your understanding.
Or in the context of Indonesia, I can't answer the question because the implementing regulations haven't been finalized as such, but based on experience in other jurisdictions such as Malaysia, there, as you do have here, a number of associations which represent the film industry, the TV industry, the music industry, and so on. And they would either collectively or individually, often collectively, make that referral through to government. I know in the case of the film and TV industry, there is a very strong, very orchestrated local coalition within Indonesia, and they communicate regularly with the government, and they will continue to do so on this particular site blocking issue.
Well, yes, go ahead, because I think there are really two ways. One, of course, is for the individual, for example, for us, the composer or the composer, to make that complaint to the relevant authored party. Of course, if the collecting society, the CMO itself, is authorized to undertake such activities, that course, the one party acting on behalf of all the right owners to file the complaint. And I would actually recommend it because then we can have multiple sources of inputs so that the relevant authority can act on things.
Baik, pertanyaan terakhir sebelum kita melanjutkan ke sesi 2. Ada yang ingin bertanya? Okay, then I will ask question then. So based on your studies, the government of either the EU or Asia-Pacific, they're really involved in protecting the copyrights for creative industry, such as film and music. But those countries are more developed countries. What do you suggest for like emerging markets, such as Indonesia, where the regulation is still weak, piracy is still very rampant? What can you suggest that us can do based on your studies?
처음에 이제 소비자들한테 이제 불법이라는 거에 대해서 인식을 제고시키는 것도 상당히 중요한 일입니다.
First of all, I think it's important to let customers know that illegal is illegal.
그렇게 하기 위해서 이제 한국에서 진행한 캠페인인데요. 유명한 배우나 그리고 가수들이 같이 참여를 해가지고 불법이 하고 있는 다운로드는 불법이다라는 것에 대해서 명확히 캠페인 하나 또 초기화는 아주 중요하다고 생각됩니다.
And to do that, South Korea had a campaign casting famous celebrities. Many people recommending to people that piracy is illegal on air, internets, and theaters.
It's a raising public awareness, yeah.
I think what was said this morning by one of the speakers was about creating a healthy film, TV industry, and music industry, a healthy ecosystem which protects and promotes the content industry. And similar to my colleague was saying, it's really based on 3 pillars: education, making consumers aware, and whether it's from a developed or a developing country, it's the same principle. Making consumers aware of the value of intellectual property not just to the producers and makers, but also to the consumers. It's also about regulation. And we've seen this morning one such regulation, site blocking, which has already been passed in a number of developing countries, is an effective process and is an effective next steps. And I think the other thing that governments can do, as I said, whether from developing or developed countries, is to try and encourage voluntary agreements between the content industry and the telecommunications industry. There are some crossover where telecommunication industries would financially benefit. They are the platform for a lot of content. But there are other areas where they are not, and they could be deemed to be even benefiting financially from copyright infringement, unknowingly and certainly not intentionally. But I think there's more that they can do from a good governance perspective, to protect the rights of the content producers. And a lot of times it will need the government to bring those 2 parties together and encourage them to come up with a voluntary agreement.
Okay, I think of course for developing countries, public awareness and education probably has slightly greater significance, especially reaching out to the lesser places, as the Vice President mentioned this morning. So I think ongoing education, public awareness, definitely. Having said that, if you look at the representation of Taiwan, you will recognize that in many territories there is already a sufficient level of recognition of the value of the creative industries, as well as that piracy or visiting illegal sites is really not the right thing to do. Which brings me to my point. In other words, I think the governments of developing countries would have to put more efforts into the enforcement or implementing the regulations that we already have in some of these countries. So So the enforcement aspect in my view is very crucial, and we should not always consider that because it's a developing country, therefore the standards should be lesser. And we should give a bit more space for people. Because it brings me down to the question of pricing. Because if you look at the pricing of music today, you can subscribe. You download the music is $1 US. Now I know, and actually to me that's a much better deal than in the old days when I buy a CD. I pay $12 for 20 songs in which I only want one or two. Most of us, as you know, listen to one or two songs on the CD, right? Now I pay $2 and I get 2 songs or 3 songs that I like, which is actually cheaper than $12 I would pay in the old days. So I think the new business model actually caters to pricing. Spotify is less than $10 US a month for all the music in the world. So you cannot argue that, at least as far as music is concerned, that movie friends are all here. That is too expensive for you to listen to music. The problem is that it's free. And when you are free, I'm not going to pay $1 for music that is available for free.
Especially $1 now is 13,000 rupiah. So it's like, I pro free then, right? Dan jadi takeaway-nya ini adalah perlu regulasi dari pemerintah yang tegas, dan tentunya untuk raising public awareness itu juga ada perlu juga dari pelakunya, baik itu juga sebagai konsumen, kira-kira butuh edukasi yang lebih terkait dengan hak cipta ini. Sekali lagi terima kasih banyak, thank you very much gentlemen for